I'm Aditya Gupta, a corporate lawyer leading the corporate, economic, and digital law initiatives at SCC. The development of our bespoke privacy legislation has certainly been an uphill task with multiple revisions and consultations. We have with us today the very experienced public policy team at Cyril Amarchand Mangaldas to walk us through this interesting journey. As W.H. Auden says, the law is the goal. What are the challenges that our law faces, and what is the road ahead? To explain, we have with us Mr. Arjun Goswami, the director and head of the public policy practice, who has more than 30 years' experience in dealing with multilateral institutions and private organizations worldwide. He's advised clients on tech policy matters pertaining to data protection, privacy, information technology, and artificial intelligence. We also have with us Mr. Varun Mehta, the principal associate, and Ashirbad Nayak, the associate in the public policy team. We welcome you for the discussion today, and it's a pleasure to have you with us. So, Arjun, starting with you, could you give us a brief snapshot of the Indian personal data protection landscape, the constitution of the B.N. Sri Krishna Committee, the white paper and the report that followed, the multiple iterations of the Personal Data Protection Bill, and finally the present Act?
Well, Aditya, thank you very much for that question, because it's a sort of interesting journey. And the journey starts in 2011 with the so-called sensitive personal data rules. These sensitive personal data rules, which were really at that time focused on things like financial information, first set out principles related to storage and purpose limitation. Of course, it was only for a particular class of data, but it was the first spark. After that comes a committee of experts, which was set up in 2012 to look at maybe broader privacy rules and regulations and law. They come out with a white paper, they come out with a report, but not much happens after that. They set out some general principles. They do take up the issues of purpose limitation and so on. They try to focus on things like interoperability across jurisdictions, because they're aware even then that privacy issues will not be confined simply to one country. There will be cross-border issues. But it doesn't go much further. In 2014, of course, there's a change in government. Still, the pause continues. And then a further spark is lit. And that is lit by the Supreme Court. And the Supreme Court's judgment in Puttaswamy, which declares that privacy is a fundamental right related to Article 21 in terms of personal liberty, is a huge push factor. And basis that push, we then get the famous Sri Krishna Committee. Now, the Sri Krishna Committee goes through a fairly extensive consultation process. They produce a white paper, they solicit public comments, and in 2018, they come up with a report and that first Personal Data Protection Bill. In some ways, at that point, the Brussels effect is still quite strong. There's very little to go on, so it hews quite closely to that. Nothing happens after that. So there's a pause again, and then in 2019 comes the next stage. Now a bill is approved by the Union Cabinet and it goes forward, tabled before the Lok Sabha. Is the Sri Krishna Committee and Justice Sri Krishna necessarily very happy with the 2019 version? No. Partly because by the time the 2019 version comes along, there are greater exemptions which are given to government. There are a number of differences on right to erasure, etc., but it's really that sparks the difference between those who were formulating the 2018 version and the 2019 version.
There the committee wasn't very happy.
The committee wasn't very happy. The 2019 version then gets placed before a joint parliamentary committee. Now, the joint parliamentary committee also goes through consultations with experts and stakeholders. And it comes up with a version in 2021, which is again different. Now, where the journey goes is one major difference is they appear to consolidate personal and non-personal data. Non-personal data had never been part of the ambit. Now, it becomes part of the ambit of the 21. This version is withdrawn by the government. And the government then introduces a new bill in 2022. And for the first time, they now call it a digital personal data protection bill, not a personal data protection bill. This is by design. This bill is different, and I think as we discuss questions, it'll become clear in what ways it's different. But it is this bill that then becomes law in August of 2023. You know, what this tells us, and I think what your question really brings out in some ways, is that, after the Information Technology Act of 2000 in India, this is the first major digital economy related legislation that's going forward. And the processes of scrutiny, consultation, care is really very extensive. I mean, this is something to be celebrated. The fact that there were multiple iterations, the fact that there was so much consideration, the fact that there was a joint parliamentary committee, that there were committees, that bills were tabled and withdrawn, should be seen as a sign that India wanted to get it right. And it had to reflect long and hard before it did it. So let me stop there.
That's very well explained. And then now we have an idea about the genesis of the legislation. Going on to Varun now. Varun, if you could share, why was there a need for this conscious policy shift from a comprehensive GDPR-styled data protection bill to a more nuanced Digital Personal Data Protection Act that we have now?
Perhaps we need to look at the context in which the GDPR came into existence, right? This is, of course, a European law meant for Europeans. And Europe, of course, in terms of socioeconomic development is at a different stage than, say, a country like India, right? We have different needs and aspirations. They have their own. So maybe somewhere down the line, it was realized that there is a need to kind of relook some of the concepts that were otherwise, forming part of the previous iterations, and maybe think of something that is more facilitative, maybe, because of course the needs here are more attuned to rapid growth and development, right? Provision of goods and services, delivery of goods and services, very important in an Indian context. We still need to provide employment. We still need to raise incomes rapidly. So you will find that some of these ideas, at least to some extent, are reflected in the current version of the Act, which we have now finally. You will see that this concept of classifying data into sensitive and personal data, sensitive and critical personal data, and just standard personal data. That has been done away with. Maybe one of the reasons for this is
which does exist in the GDPR.
It does, and this obviously comes with its own implications for data fiduciaries or controllers, because of course there's a need to have this segregation internally and treat them differently and apply various standards from a business continuity point of view. Perhaps it's easier to do it this way, as we do it in India now. We will be doing after this act. That's probably one of the reasons why we see India moving away from a GDPR style legislation. I mean, another example is if you look at provisions relating to cross-border data transfer, right? We've adopted a much simpler approach, I would say, compared to the GDPR and their understanding. I mean, here it's a more straightforward approach of by default data can be shared across borders, and
you have to wait for adequacy decisions.
Exactly.
Like it is in the
exactly, yes. And past experience does suggest that these could sometimes turn out to be a bit cumbersome. So maybe given our regulatory capacities, etc., here call was taken that you just allow transfer of data internationally across jurisdictions, unless in cases where the government maybe feels that certain jurisdictions should not be allowed that leeway. So those are some of the facilitative changes that have been made. And apart from that, generally, if you look at the scheme of things in our version versus the GDPR and the other iterations, you'll notice that this is a much shorter framework, right? It's also easier to read, bit easier to understand, by and large speaking. And there's something I think the government has stated also before, that they wanted something which was much more accessible to the public. I think this is an important feature, because you see this act in terms of scope and applicabilities is going to impact everyone. I mean, almost every citizen of the country who has an internet connection will be a data principal, right? So it does really affect the general population of the country. So that definitely, I think, is a factor which played a major role.
And you'll see that the twists and turns of policy, what Arjun just mentioned, they haven't in any way eroded the robustness of the legislation.
Generally speaking, I think a more practical approach has been adopted here. Of course, these are very early days, right? The act is not even in force yet. I mean, we need rules to substantiate a lot of what the act sets out. And these, of course, need to be notified and come into force at some point. So a lot of this remains to be seen. But I mean, the hope is that, given that it's not as, it's a bit more light touch, maybe. So the hope is that it maybe will pan out in a good way. But yeah, we need to wait and watch to see how this
that has to come out back in terms of the rules. Thank you for explaining the rationale of the enactment. Now, Ashirbad, coming to you, we have clarity over the legislative scope of the enactment. Could you give us an overview of the various facets or nuances of the Digital Personal Data Protection Act that we have now?
Absolutely. And, as we often say, the devil is in the details. And for an act which, as Varun mentioned, is going to affect all strata of society, it is indeed a lot of details that we need to focus on. So what I'll try to do is I'll try to give a composite imagery covering all the various actors and all the various nuances of it. At the fundamental level, this act involves two critical players, the data fiduciaries and the data principals. Now you can imagine, and of course the data fiduciary is accompanied with an associate, namely the data processors. You can think of them as, players in a play, so as to speak. So if a data principal has something that he or she needs to be done, they move on to the data fiduciary, and on the premise of consent, and upon providing adequate notice, the data fiduciary shall process the personal data. Now, there are certain cases under which the personal data can be processed without requiring consent. And we have a very limited scope under the Act, which provides for grounds of certain legitimate uses. And These range from things such as natural disasters, medical emergencies, provision of subsidy, benefit by instrumentalities of the state. So there exists that mechanism that for certain limited cases, you can process the personal data of an individual.
Now, there's also a very unique aspect of processing of data for employment purposes, which does not find a mention in the GDPR.
Absolutely. And of course, to err on that side, I think the GDPR also provides some other grounds of processing, which the DPDP Act does not. For instance, on the basis of a contractual necessity. So those are certain limited grounds which the DPDP does not find a mention in. Now, to manage consent, right? You've got a player which provides consent. You got a player which processes your data on the basis of that consent. And there'll be multiple such players. So to streamline the entire approach, this act provides a fairly unique concept known as consent managers, a parallel of which is not seen around the world. And if it comes to fruition and it's sufficient, it can indeed be a benchmark for the rest of the world to follow. Consent managers are responsible for reviewing, managing, and providing your consent. So now this entire concept of consent fatigue, which we deal with a lot, like you see a thing, terms and condition you accept. Now you've got a consent manager to take care of it. So that's a fairly well thought of provision. So now,
who is this consent manager? Is it a person? Is it a body corporate? Is there some clarity that we have in the act?
So we are waiting for certain clarity in terms of who can be a consent manager, but that will only come through the rules. I don't think the act itself specifically mentions the criteria on which a consent manager is to be appointed or the qualifications for the same. So I think there's a little bit more of wait and watch that we need to do, and hopefully touch wood, it comes down in the near future. But in addition to it, so we've got all these players. Now we need someone who ensures that all these players are functioning smoothly. And that's where we get the data protection board. Now, a conscious call was made that the data protection board is to be a board and not an authority or a sectoral regulator, unlike what we have in the EU or other jurisdictions. The DPB has certain clear functions in case a data fiduciary is affected. So, your data in principle is affected. He or she can approach the board, seek recourse, and the board provides a graded system of penalties which are to be imposed on a data fiduciary. And these can range from, 50 crores to 250 crores. But at the same time, they also provide for penalties on a data principal who may try to misuse the provisions. And that ranges up to INR 10,000 rupees. Now we've had this entire gamut of players. Are there certain key things that we need to be aware of, certain key definitions? Because as I mentioned, it's all in the details, such as processing. And processing has been given a fairly wide mandate under this legislation. And it can include something such as sharing, storing, altering the structure. So it covers a vast array of subjects. So which means that all these players and all these dynamic factors that are there will affect all the individuals that rely on some sort of personal data in India. Now, interestingly, one key character that we are missing in all of this would be children. Because, again, are they even capable of consenting? We know from other statutes that it's not as certain, that their consent is not as certain. Contract Act, for instance.
Exactly what you were touching upon as to whether the children are adequately protected under the Indian legislation.
That's a fairly good question, and in my humble opinion, I do think that they are. And the reason being, the Act provides a lot of safeguards under certain sections in the legislation. For instance, there's a catch-all provision which states that you cannot process personal data for anything that is detrimental to the well-being of a child. And additionally, if you need to process the personal data of a child, you need to obtain verifiable parental consent. So in practice, it won't possibly be that, some random lawful guardian or some random person is providing consent on behalf of a child. It needs to be verified. Now, how that pans out in practicality is, of course, something for the rules to provide clarity upon.
That's a challenge for jurisdictions world over.
Absolutely. I mean, you look at jurisdictions in the US, in EU, everyone without fail grapples with this. Like COPA in California, everyone grapples with this same issue. So it's not something that's unique to India. And finally, of course, for children, there's another major provision which prevents tracking and behavioral monitoring.
Yeah, that's only in the case of children in the context of the Indian legislation.
Correct. And it'll be interesting to see that, you have all these provisions in place. How are they going to be applied? Like, in the sense, it's well thought of, it's with well intentions, but will it have any potential repercussions on, say, normal activities that a child wants to do? That will be critical to see in the near future. So I think that's a fairly comprehensive overview of the DPDP Act.
Absolutely. And speaking of the age of consent when it comes to children, I believe the Indian threshold is 18 years.
Absolutely. Correct.
Great. That's very well explained. And now that we know the nuances of the Indian legislation, could you also explain that how is it different from the GDPR?
Absolutely. And so what we always think about in terms of data protection legislations around the world, the first thing that comes to mind is the GDPR. And that's also because they had the first movers advantage. Like, you trace European law, you can go all the way back to the Data Protection Directive of 1995. And they have been quite active in this field. The first iteration, the first version of GDPR, which came about, was in 2016, the official version. And then they implemented it in 2018. So if you look at where we are in India right now, which is 2024, they have an 8-year head start over us. So it's fairly natural to have that compare and contrast with GDPR. And as Arjun sir mentioned previously, that influence, that Brussels effect, always takes place. But what we see in this legislation is that it's very consciously designed to be tailored towards India's needs. So certain critical differences that we demarcate against GDPR. First of all, is the light touchness of this legislation. GDPR is relatively broader, it's relatively more prescriptive. This I would consider is to be slightly more business friendly and slightly more geared towards balancing privacy with business friendliness. Second major difference would be in terms of categorization. So GDPR does categorize on the basis of personal data. Over here in India, we pass that onus to data fiduciaries, and we categorize on the basis of significant data fiduciaries and normal data fiduciaries. So if you're significant, you have additional obligations, BIAs, periodic audits, appointment of data protection officers. Others can be such as this concept of consent manager, which again finds a parallel only in India and nowhere else around the world.
And in the GDPR as well. The consent manager, yes.
And finally, the grounds on which you can process. And that's a critical thing because India has only two limited grounds: consent or legitimate use. GDPR, you have 2-3 more. One of which, of course, as I mentioned, is on the grounds of performance of a contract,
which is the contractual necessity ground.
Absolutely. So I think it differs. And I think it's also rational that it differ because, as I mentioned, it's been an 8-year gap between when the GDPR first came out and where we are. So we've lived and learned through how the GDPR was applied in those jurisdictions and made our own pick of the best practices. So I think we are in good hands with legislation.
Indeed. Also, there's an important facet of the GDPR which says that the controllers, they can process data for their own legitimate interests. That is something that we don't find in the Indian legislation.
Absolutely.
So that is one aspect. And speaking of a few additional rights that we have, which is the right to nominate and right of grievance redressal, that's also something which is very novel to the Indian legislation, if you could reflect on that.
I think this is something that I forgot to touch upon when I was referring to the players in this entire ecosystem. So now you've got consent or you've got legitimate use and your personal data is being processed by the data fiduciary. Now, what happens if things don't go the way they're supposed to go? If things go awry, how do you manage it? The way in which you do is you empower the person providing his or her personal data with certain rights. And these rights can stretch from the right to access, like you've taken my data, I want to access it. The right to correction. Hey, I provided you data. It's not accurate. I'm not getting the results that I want. Why don't you upgrade the data to the latest possible version, or right to erasure. And in fact, it's one of the few legislations, if not the only legislation in the world, which provides for a mandatory period of erasure. So nowhere else would you find this parallel that once data has been collected and processed and the reason for which it was collected has passed, the data will have to be automatically erased. Well, that's something fairly unique in watershed. And of course, the right to nominate, and which is quite crucial, right? Like we see it in a lot of cases, such as companies who have unclaimed shares, or in insurance where people have unclaimed insurance policies. So what happens if, say, you pass away or something happens to you? How is your personal data going to be managed? So now you have this authority to nominate someone on your behalf. And in the case of an emergency, or in case of, God forbid, something happens to you, that person can manage your personal data. So it's fairly structured, and there's going to be some fair structure of continuity from one data principle to another through the course of this act.
When we also talk about the EU GDPR, there is a right wherein the data principal can restrict the processing of their data. Do we have such a right under the Indian legislation for the data principal?
Consent, once given, can also be withdrawn. So there's no hard and fast prohibition that once you provided consent, it exists in perpetuity. So that right is definitely provided. And say for the data that you've already provided, you want to ensure that this particular data does not get utilized further. You have the right to erasure. So a two-fold mechanism exists: withdrawal and erasure.
Perfect. Great. Now we've understood the important aspects of the legislation. Varun, coming to you, what changes can the common people expect when the rules are notified and the act is enforced? Will there be a flood of consent notices? Because there's a prerequisite in the act which says that every request for consent has to be accompanied or preceded by a notice. So what are your thoughts on that?
Yeah, so of course there will be changes. I mean, it is after all a new data protection regime, right? And one which didn't really exist in such a robust manner, at least prior to this. So of course there will be changes. There may even be certain disruptions and all of that. Obviously, data fiduciaries, that's companies would be trying to get consent as soon as possible, so that business can flow as usual. So that would be there. I think a couple of factors though would make this process maybe a little bit smoother and limit the amount of disruption really that the market faces. One is, of course, that it is hoped that the act would come in with certain compliance windows, right, where time will be provided to players to really comply with all provisions. So we may see a staggered kind of easing into this rather than an overnight change in processes. So that may make it easier not just for users, for common individuals, but also for the companies.
Akin to the transition period that we had in the EU once the GDPR came into force. I see.
To be to the benefit of people, the country. And another factor to consider here, I think, is that the Act again is quite practical in terms of legacy data, in terms of data that already is being processed, before the Act really comes into play. The approach taken here is that for this kind of data and for this data to be processed post the Act's implementation, a notice would be sufficient. There may not be any need for express consent unless the purposes for which such data is being processed. If that gets updated, then of course you need to seek fresh consent, because consent is the basis for all kind of processing mostly that happens under the Act. But provided that data as was being processed continues to be processed for the same purposes in the same manner, the Act will only require notice to be intimation essentially to be provided. That may again help to quite an extent, because it would kind of avert a scenario where you suddenly have to provide fresh consent for to each and every data fiduciary who processes your data, and this can be quite large in quantum, right? Because most of us are signed into. I mean, I don't remember the number of apps that I've signed into and how many accounts I have. So of course that could be problematic if all of a sudden I have to consent to 100, 200 different applications. And so I think things may not be as bad as some may fear.
So that's certainly a relief for businesses that they don't have to seek consent for the past data that has been collected.
Relief for businesses, relief for users as well. I mean, it's a nightmare scenario otherwise, and it really loses its point if I have to sign on to 100 papers without really reading any one of them.
Absolutely. And this brings us to a very important point of MSMEs. Every jurisdiction wants to protect small businesses. So when it comes to protecting these businesses, what is it that the Indian law has in mind? Like, are there some special technical and organizational safeguards that are recommended?
Yeah, you're right. The Act, in fact, does have a requirement, it does place an obligation on data fiduciaries to implement technical and organizational measures for protection.
Which is the privacy by design concept, the Kevorkian principle of data protection by design and default, and then coming to the Article 25 of the GDPR, which also talks about the organizational measures, pseudonymization, anonymization.
Yes, exactly. You're right. The only difference being that here there's not a lot of prescription attached to this obligation. It is left primarily at a principle level, where the provision I think barely states that data fiduciary should implement such technical and organizational measures as may be appropriate. I think so. I mean, the implication of that is potentially depending on how all of this gets interpreted as things move forward. But again, it is hoped that this would be interpreted in a practical manner to provide leeway to data fiduciaries, because of course we're dealing with data fiduciaries of different shapes and sizes, and that engage in very different kinds of processing. As we discussed, processing can mean a lot of different things, right? So measures, therefore, I think it's good that the Act is not extremely prescriptive in that sense, because ultimately what we're looking at an outcomes based thing, right? As long as data is secure, protected, and processed, in a lawful manner, that should get the job done. We especially since this is the tech sector, right, which keeps evolving, keeps growing. We do not want to end up in a scenario where this regresses into one of those domains where compliances are to be followed just for the sake of compliance rather than outcomes. So I think it's good, therefore, that it appears that the Act is not seeming too prescriptive. This may help businesses, especially as you mentioned at the beginning. Small businesses are going to be the ultimate beneficiaries of these, because the larger companies they have the means and resources to comply with a lot of compliance-heavy obligations. Is the smaller data fiduciaries, smaller companies out there that may face problems if things get too rigid. So yeah, this should help them, I think.
Interesting. So we're following a very outcome-based approach.
Yes.
Wonderful, wonderful. And taking a cue from what Varun said, Arjun, do you feel that we would need a very streamlined approach in terms of the enforcement of our legislation when it comes to addressing the regulatory overlaps, especially when all the new legislations are in the offing, like the ex-ante Digital Competition Bill, the Digital India Act? So what is the approach that we should be following?
So great question, Aditya. I think let me try and answer this in 3 parts. So first, I think inter-regulatory conflict is not something that's new for us in India. And 2 cases that, of course, come to mind immediately are one in 2010, when unit-linked insurance plans came forward. There was a conflict between two regulators on the same subject matter. The Securities Exchange Board claimed that they were the regulator because they saw this as part of the securities market. The insurance regulator, IRDAI, claimed jurisdiction because they claimed that this was actually to do with insurance. And ultimately it was settled in favor of IRDAI. It went through various government and court processes. That is a case of subject matter between two regulators. The second case is Bharti Airtel. Now, this is maybe more interesting by way of background because it involves a conflict between a cross-sector regulator, namely the Competition Commission of India, and a sectoral regulator, the telecom regulator. And ultimately where the court came out on that is to say that the cross-sectoral regulator is not ousted, but needs to defer as a first step to the sector regulator in whose competency this falls. In other words, the telecom regulator, and subsequently, if there are issues of market structure, then the Competition Commission falls into place. So this broadly is the backdrop to where cross-sector regulation and sector regulation came out. Now, in this legislation, this issue of interregulatory conflict has actually been avoided. And it's been avoided because the Data Protection Board is not a regulator. It is by design not a regulator. The government have kept that regulatory authority unto themselves. There are a lot of questions which were asked around that, about the authority of the Data Protection Board, etc. But I think there was a lot of understanding within the government of what happens when you start creating new regulators and the potential of conflict. And the chance of having a whole of government approach, so-called, becomes much better if you keep that within the government. So that is the first part. The second part is the design of the legislation itself. Now, the way the legislation is designed is that it is a sector-agnostic, cross-sectoral piece of legislation.
I see.
Data issues appear across sectors. Financial sector, e-commerce, you name it, data will be there. So the way I think the legislation has approached this is to say that there is a minimum baseline standard that is being set by this law. No sector can fall below that baseline. And the provisions which are laid out under the Act allow for this Act to assume primacy if any sector falls below that minimum standard. Having done so, if sectors, because of their special needs, require additional measures over and above that minimum baseline, then the sector should be free to do so, because the Act rightly, I think, in my opinion, did not want this cross-sectoral law to start interfering and disrupting sectors which in some measure have been heavily trodden by sector regulators, have been considered very carefully by sector regulators. And the classic example of that is what has happened in the financial sector, where the Reserve Bank of India sets out certain rules on data localization, and the basic minimum baseline is set under this Act. So this is the second part, and the third part is actually the provisions itself, which allow for this kind of coordination between baseline and sector to operate. So I think in that sense, I'm optimistic that we have learnt lessons from the past. We have found ways of deliberately avoiding those conflicts and actually playing to the strengths and recognizing the strengths of existing regulators and ensuring that the baseline is properly protected by an appropriate data protection board.
See, that's perfectly explained. Also, what is the nature of the data protection board? Is it a quasi-judicial authority? Because it's been invested with investigative powers, some adjudicatory powers. It can impose penalties. What is its exact nature?
So it does have some investigative and adjudicative powers. It has, I think, got an interesting composition where there would be people who would have technical competency in addition to people who would do those types of investigations and adjudication. There is an appellate process that goes to the so-called TDSAT authority and then from there to the Supreme Court. So it's a fairly streamlined process of appeals. Its basic job is, if there are violations in the Act which data principals complain about, that they can take cognizance of that and impose penalties. It does have the power to look at things itself. But generally, the way I think the Act is operating is to say to data fiduciaries, you are the point of liability. We're giving you principles-based do's and don'ts. Be aware of it. If you violate it, there will be fairly stiff financial penalties going all the way up to 250 crores. So this is not minor. And to avoid that, please make sure that you satisfy your obligations. To follow on from Varun's point, because it's outcomes-based, we're not going to inquire into how you satisfy these obligations. I mean, that is an input matter. Make sure you do it. But if you don't, the outcome is going to be that these penalties will follow and the Data Protection Board will kick in and other consequences will follow beyond that. And we're going to make this relatively easy for people to raise issues related to penalty in order to ensure that. Now, this is important because this is not about data principals seeking compensation. If they wish to seek compensation, they have to do that in the courts. So therefore, the type of complaints that will come are not necessarily going to be motivated by people seeking compensation. They will be for cases where data fiduciaries have genuinely violated their obligations. So the design kind of is in that direction.
I see. So there's a carrot in the form of self-regulation.
Correct.
And a stick in the form of penalties.
Correct. We, in other words, we say that we believe that you'll do the right thing, but if you don't do the right thing, there'll be a consequence, right?
Indeed. And do you feel the board has enough teeth in comparison to the international counterparts?
So, I think this is still something where we'll have to find out what happens. I mean, the board is going to be constituted. We'll have to see how it executes its functions. Generally speaking, in India, sometimes our greatest attention is when bills are being formulated and are about to be passed, and then people's attention move on to the next shiny object. But in fact, it is implementation that really matters. And that's a test which, the board will have to satisfy. But there is a lot of hope, a lot of expectation. I mean, all this time, to go back to my earlier answer, has been invested in coming out with this legislation. So there is a big responsibility on the members of this Data Protection Board to get it right and to show that where the teeth of the Data Protection Board are required, they will actually exercise it. That is, after all, what the government have always said, that this is a piece of legislation that, whilst business friendly, also seeks to protect the rights of the digital nagrik, or the digital citizen. And the Data Protection Board is an important institutional aspect of that.
Absolutely. And having said that, do you feel our courts and the appellate authorities, they are ready for privacy disputes, for handling privacy disputes?
So I think there are several aspects to this. The courts are certainly becoming very technology geared, and we see this in the way in which they're approaching technology in their processes. We see it in the specialized benches that are now being established at the Delhi High Court. Courts ultimately, in terms of the way they operate relative to technology, will also be dependent on the advocates and lawyers who appear before them. And we are seeing a brand of lawyers, both transactional and disputes, who are focused on technology. There are whole branches of firms which are now focused on these areas. So the servicing of it will also improve. And I think taken together, this will probably provide for a good forward path, right?
Absolutely. And there's a provision in the legislation itself which says that as far as it is practicable, the Data Protection Board and the adjudicatory authorities, they have to operate as a digital office.
Correct. So this is again digital by design. They're trying to improve the way in which these kinds of authorities would operate and function. I think these are all very hopeful signs going forward. And the fact that, ultimately, as we were saying in the historical journey of this, at the apex level, Puthuswamy was such an important judgment. It's going to be important on the judicial system as a whole to play an effective role.
So that will be the touchstone, basically.
That is going to be the touchstone, and I think they will continue to be very conscious of that touchstone. There is, of course, post Puthuswamy now, a clear legislative framework which sets out rights and obligations. So beyond that touchstone, there's now the touchstone has sparked a framework which the courts can also look to, and I think that means that this is a case where the judiciary and legislature and executive branch will be combining forces, basically, to make sure that the balance is hit right.
Perfect. And the Act, from what I know, also envisages the process of mediation for privacy disputes.
Yeah.
So how do you feel that's going to pan out parallelly with the court system?
So, I think that the alternate dispute resolution mechanisms, particularly on mediation, have been around for a while now. Ever since the 90s, the courts have been seeking to promote that as a way of reducing litigation that doesn't necessarily need to come into the court system. Now, if one takes that in combination with the kind of penalties that could be imposed by a data protection board, and the fact that those penalties then have to be paid up, there is going to be some incentive to settle matters rather than to play it long. In other words, the game of saying that I've got a court system that maybe delay ridden, and I'm going to see out a data principle because I've got deep pockets. I think that is something essentially that's being nixed through this process. So the combination of particularly the mediation part of alternate dispute resolution. Arbitration can be expensive, but mediation can be fairly quick, pretty effective, and taken in combination with those data protection board powers and the penalties which are provided for under the Act, I think provides for a good way forward.
Wonderful. That's a very fairly detailed explanation of how the enforcement and the adjudication process is going to pan out. Coming to Varun now, since the clamor has been so much around having a robust AI framework in place, having an AI legislation, the whole debate surrounding the Digital India Act, what do you feel, or how do you feel the intersectionality between the data protection and AI legislation? How is it going to pan out?
Yeah, so data, of course, is very central to AI and AI models. I mean, the models that are most relevant these days are Gen AI models that are mostly based on LLMs or deep learning. Data is essential here, right? These models exist because they're trained on massive amounts of data, and therefore, develop the ability to function autonomously. So, of course, without access to data in that quantum, in that measure, these models wouldn't function as they're starting to function. We're beginning to realize how capable they could be. Uh, so generally, data, of course, plays a very crucial role with in the field of AI. Now, whether or not personal data is as central will really depend on what kind of model we're talking about, what kind of business model the AI deployer really employs. Of course, the moment personal data becomes central to the training of any AI model, if at all it does, then questions of data protection will become relevant. Now, the data protection laws in general, including the one we have here, are again sector agnostic and technology agnostic. So they will apply in equal measure to AI as well. So, conditions such as the need to obtain consent is very central again to data protection regimes, and the purpose limitation. These will apply in equal measure to any sort of AI accessing or processing or being trained on personal data, and these will have to be maintained. But given that AI in itself is a unique kind of technology, because what you're really talking about here is autonomy, right? And agency. So the question that really would become relevant, not just from a data protection point of view, I mean, it is very relevant for data protection, but even in other areas, which we're starting to see now, like IPR. So here, liability is what becomes really important, as in where really should liability lie in case of harms occurring. So harms could occur on account of AI, multiple measures and means, right? Including, I mean, in the case of data protection, potentially with data leaks, data breaches that occur. So what we really need to look at is where can liability be affixed in case AI models, AI systems end up violating data protection norms and obligations. I mean, in case they leak in details about individuals, right? In case they trained on data without consent of individuals to begin with, then whether their outputs end up divulging details that they weren't supposed to. So what really needs to be developed over medium to long term is our frameworks on AI regulation that really answer these questions on liability. The extent to which AI deployers should be responsible for harms that occur because of their systems. So I think moving forward, those will become central to AI frameworks that take shape and form. And yes, given the importance and centrality of data and all of this. I think in the EU, for example, I mean, their own AI Act, which is again a benchmark right now for AI regulation, does focus a lot on data and privacy. So moving forward, one will have to see whether these additional questions are addressed specifically in an AI legislation, if at all this were to ever take shape, or whether data protection laws will separately have to, start recognizing implications of AI and data, which may be relevant only in an AI context. So we'll have to see how this pans out.
Indeed. And if you were to understand this further, an AI tool would definitely be a data processor. Whereas when it comes to determining the means and purposes of this processing by that AI tool, it would be the data fiduciary that would be responsible for that.
Yeah, again, this goes back to the question of really whether you can distinguish an AI system from its deployer. I think it's a very central question generally in AI jurisprudence and how it will develop. Because one way of looking at it is that the deployer really is the fiduciary who determines the means, and the processor is the AI system. But I mean, another way of looking at it is that you do not distinguish between the two, that the AI system is itself, because I mean, how data fiduciaries themselves are defined as they're defined more in the context of a person, which could mean a company, a business, or an enterprise. So anything that a tool of the company performs becomes the action of the company itself. So essentially, whether or not we apply strict liability in these scenarios, this will become the question. I think
This is the age-old question also, whether AI has personhood to be constituted as a fiduciary.
so would really depend on what policy objectives are across the world. I mean, jurisdictions that really want to are proponents of AI really and would want liabilities not to flow back so easily to deployers could take a more liberal approach. But those that are more conscious and aware of the harms and the implications of AI may really want stricter liability to be ascribed to those who deploy it.
Indeed, and having reflected on the intersectionality, coming to the Indian regime, do you feel that the penal mechanism that we have now, is it appropriate in the Indian context?
You mean the penalties sent out?
Yes.
It is appropriate in the sense that we've what we've seen here in this act is that they've opted for a financial penalties regime, right? So this means that the act does not really go down the criminal liability route. I think that is a welcome step, of course, because this has generally been a concern and a complaint of businesses and enterprises generally, that criminal liability is what scares away investments into India. So a financial penalties regime is again in line with generally what's by and large being practiced elsewhere in the world. So I think that's good to maintain that kind of parity. The quantum of penalties also seems to be quite strict, which may not be a bad thing, provided that they're applied judiciously and they're applied fairly. Because at the end of the day, again, we're talking about a regime which otherwise is very light touch, right, and not too prescriptive. So there is a need to wield a strong stick at least, so that you don't let things go too liberal in terms of upholding the law. So yeah, again, it does seem appropriate and rational on paper. Again, but as has been spoken about enough number of times today, all of this would really depend on how these things are finally executed on ground.
Absolutely. And also, I feel that though there's a penal mechanism in the Act, we don't find any particular provision dealing with compensation for the data
That can be claimed by data principals. Yes, that has been a fairly obvious omission. Omission, I'd rather say, it's not definitely not provided for under the Act. This is also something that actually form part of Section 43A of the IT Act, which is in a way, the parent provision for this entire law.
It was the erstwhile provision, and now it will be done away with as soon as the act.
Yes, is enforced. So yeah, there have been questions that have been raised about the fact that this right, which was statutorily provided for earlier, has been done away with, has been taken away. Of course, I mean, data principals are always free to approach courts. I mean, you're seeking damages even without a provision, but of course, it would have been much more straightforward had it been statutorily enshrined. So yes, I think let's see how it pans out really. And again, the purpose of the act, I think, was more and the regime, the penalties regime, was more punitive in nature. That seemed to have been the purpose.
And we might see this restitutionary element coming later when the rules are notified, or subsequently when some more rules come out.
Rules can really rectify this because of their limited ambit. But again, even the act is not really set in stone. These acts keep getting amended, right? And of course, this act could get amended down the line. So maybe if the need for this arises, if this does really become a pain point which deserves redressal in the future, yeah, the act is always amendable in that sense.
I see. Now we have a very fairly, I'd say, a comprehensive view of what the legislation entails. But could you throw light on the aspect of extraterritoriality of the legislation?
Imperative to remember, right? Like first, when we set this context, as has been talked about earlier, this is the legislation designed towards digital personal data. And we live in an age where data is the fuel that drives this engine of growth and innovation around the world. Like more and more countries around the world are becoming data centric. For any large scale, digital public infrastructure project that any government needs to execute, you need personal data, or you need data for that matter. A company wants to offer tailored services, targeted products, you need personal data. And data, unlike other commodities, if I may so refer to it, is not confined within the physical borders or territories of a particular country. And unlike, say, some other kinds of goods, you have an excise department sitting somewhere at some port or at some airport somewhere, which can ensure that adequate checks and balances are put in place before something flows out of the country and something flows in. Data is not hindered by those kinds of restrictions. Like all it takes is a couple of clicks and a few seconds, and data can flow from one continent to another. So it becomes a challenge. Honestly, it becomes a challenge for any legislator around the world trying to regulate. The fact that a malicious actor sitting somewhere else can adversely affect the personal data of an Indian citizen or any citizen, or can utilize that personal data for certain negative purposes. Now, how does the Act per se grapple with it? The Act provides recourse through the form of Section 3 in the legislation, which states that not only are the provisions of this Act applicable to processing of personal data within the territory of India, but also to processing of personal data externally, outside the territory,
when they are providing goods and services in India.
Correct. So that's the caveat which has been there. So as long as you process personal data extraterritorially, but that is done for the purpose of providing certain services or benefits or action.
It can be for payment and not for payment.
There's no bar. There's no bar within this.
It can be gratuitous services as well. And, okay.
But the trick here becomes that, say something goes all right, how do you actually enforce this? So this Act provides, and the Act provides this recourse that this provisions, say penalties and everything, is applicable extraterritorially. Now that has a lot of interface with the civil law provisions that we have in our country. So we used to have Section 13 and Section 44 under the CPC, and we used to have an annexure right next to it, which said that if an Indian judgment is provided, that can be enforced if it's a reciprocating territory. So we had a concept of reciprocating territory. Now imagine if, say, some individual, some Indian citizen approaches the Data Protection Board, informs that, some actor sitting somewhere misutilize my personal data and I want recourse. Matter goes to DPB, say from the DPP, it goes to TDSAT, then it goes to the courts as is the appropriate channel, as Arjun sir mentioned. And subsequently, there's a judgment. The kicker comes in when you try to take that judgment and you try to enforce it around the world. So that will be quite critical to see that how this particular process is executed. And if it's done seamlessly, then actually you have a lot of strong backing.
In respect of that, I believe there's an exemption also in section 16, which talks about the data that's processed outside India for data subjects who are not in India. So that data processing is completely outside the ambit of the legislation.
Absolutely. And what's important, I'm glad you brought up section 16. So what will be interesting to note is that in the November 2022 iteration of this legislation, which came out, the approach followed for transferring or cross-border transfer of personal data. And mind you, cross-border transfer of personal data and data localization has been on the government's mind since years and years. We've had RBI notifications for it. There were diktats given to WhatsApp that you need to have mandatory local storage. Every version of the PDP bill, the erstwhile PDP bill, has made some mention to it. So the provision under the erstwhile section 17 of the DPDP bill of November 2022 used to state that this is a blacklisted approach. You can only transfer data outside the country, provided that that particular country is in a whitelist. So you're barred essentially from transferring data freely. Now that position was completely reversed, which makes this a lot more business friendly under section 16, as you mentioned. Now we have a whitelisted approach that you can transfer data cross-border without any restrictions.
You're kind of following a negative adequacy here.
Correct. Subject to the caveat that a particular country has not been put on a prohibited list. And that is going to come through, if and when a country is to be barred, that comes through a government notification. What will be interesting to see from a practical standpoint is how does that materialize? Like, say there's some, God forbid, some kind of malicious attack towards India, something that happens. Will the government provide adequate time period before blacklisting a country? Or is it something which is done instantaneously? And once that happens, how quickly will all of these data fiduciaries get time to respond? Like, okay, do I stop it immediately? Or do I stop it in a graded manner? So those are some very interesting questions.
There's a 72-hour limit in the GDPR, but we are yet to know about our time limit, which will depend on the rules that are notified.
Absolutely. Absolutely. So you get these very interesting dynamics of a jigsaw, which will get resolved only through practice.
And do you feel that in future we could also adopt the European standards for data transfers when it comes to the binding corporate rules? And there are some contractual safeguards that are prescribed or self-regulation. Do you see them finding a place in the Indian data protection landscape at some point?
Actually, take a page from what Varun mentioned earlier regarding the practical necessities that India faces vis-a-vis the EU, and EU being a relatively more developed jurisdiction, having a couple of years of head start over us, is also different from us because they have a layered system. So not only do you have the regulatory, the GDPR, which is applied across the European Union, you've also got state-specific legislators. You've got state-specific laws. So you have the dynamic, and for them to ensure that data flows smoothly from one country to another, they need to have these kinds of provisions. What EU GDPR is concerned with is that if you transfer data from outside the territory of European Union to, say, a third-party country, that country needs to have similar standards of protection so that, personal data's confidentiality, integrity, and everything else can be maintained. Will we see it in India? Absolutely. I do think that this act is a step in the right direction. And of course, you can't have everything happen all at once. Things happen gradually. We learn with practice. At this point, we have certain elements which allow transfer of personal data across borders. What are the standards that it will be subject to? That is left to the sectoral regulator. So Section 16 also mentions that this is a baseline obligation. If a specific sectoral regulator, say the Reserve Bank of India, comes out tomorrow and says, look, you can only transfer personal data provided they have this kind of encryption or this kind of central storage or these many people can access. And they actually do, like master directions and master circulars of the Reserve Bank of India do. They even talk about temperature, like as far as I've read, they like of the room where it's to be stored and everything. They are quite detailed that way. So there's nothing prohibiting a sectoral regulator from specifying these. So the question that you asked, like, will we have similar standards come into place in India? Absolutely. I think some of them already are.
That's very important, and that in a way concurs with what Arjun said in terms of the sectoral committee and the special regulators getting their due share when it comes to adjudication of disputes in line with the Bharti Airtel judgment. So, Ashirbad very well explained the aspect of extraterritoriality. Now that we know the details and what the law entails, Arjun, do you feel that bespoke privacy legislation is here to stay?
Thank you for that, Aditya. So, I think we have on the sort of, if we look at the data, we are looking at a $5 trillion economy where the digital economy will be $1 trillion. Now, where's this coming from? I mean, there is a massive drive on the private sector side in terms of large companies in the digital economy, many of them world-class, carrying in their wake a whole supply chain of smaller entities. We have a massive drive on the public side, digital public infrastructure, not just in the financial sector, but also in other sectors, spreading and providing that supporting architecture to the growth of the digital economy. And look at the picture, Aditya, on the demand side. I mean, for the first time, I think in 2023, over 50% of our very large population have become users of the internet. And by some projections, the year-on-year growth is around 8%. So if over 800 million are already users and we're seeing 8% growth, the digital economy is massive for us. And against that backdrop, the Digital Personal Data Protection Act becomes a crucial law, really. And its relevance is, undoubted. Now, having said that, of course, the true test of its efficacy will lie in what happens with the rules and how the Data Protection Board operates and how effectively and efficiently it operates. So in that sense, if you like the poems of Robert Frost,
Yes.
I quite like them. So there's one which says, "The woods are lovely, dark and deep, and we have promises to keep, and miles to go before we sleep." So we have promises to keep. We still have miles to go before we sleep. But I think, this is an interesting time and a great time and an optimistic time for the digital economy in India.
Wonderful. And we end on that optimistic note now. That brings us to the end of the discussion. It was great interacting with you all. Thank you so much for joining the discussion. I would also quote Robert Frost here. I took the road less traveled by. Let's see where the road that we've taken with our bespoke privacy legislation takes us. All that now we need is some light in terms of the rules. Thank you very much, and we look forward to having more such discussions.